Now the next session is going to be by Ms. Madeline. She is going to be talking on the ethics for mediation. So request everybody to kindly pay attention to her, please.
And say nothing but the truth, and God help him, not the judge. The establishment of a framework for international settlement so that we can have harmonious international economic relations. So we need harmony. Now, the scope of application. Article 1, which is normal, defines the essential parameters of the convention. It identifies the requirements necessary for settlement agreement to fall within the scope of the convention, and specifies the inclusion. As you know, as lawyers, for every general rule there is an exception, otherwise life would be impossible. Requirements of settlement agreements resulting from mediation is also mentioned in the convention. One of which is it must be in writing. Are all mediation settlements in Bangladesh in writing? Some of them were oral. The others which are oral. So you can go to court and prove them. But now under the international convention, they must be in writing. Now the word writing, the way it appears there is very simple. But when it comes to a dispute, it can be difficult. International, it must be international, not local. At the time of its conclusion, based primarily on the place of the business of the parties. Are you following? Place of business of the parties. We shall see the exceptions. And it must be commercial in nature, not family disputes. You don't take family disputes to international arbitration, mediation. So I heard about dispute between husband and wife. Convention does not deal with those matters. By excluding transactions engaged in by one of the parties, a consumer, for personal, family, or household purposes, or relating to family inheritance or employment, these are not for international mediation. Then there is a clarification in Article 2 of the terms, one of which is to clarify what does it mean by internationality of the mediation. It provides solution to one of the places where the party has more than one place of business, because there are parties which have more than one place of business. The relevant place of business is the one that has the closest relationship to the dispute. So it is the place where the dispute arose. If there are, the party has more than one place of business, because we are looking at resolving the dispute, not the parties. Now the closest relationship. The other one, where the party does not have a place of business, reference should be made to the party's habitual residence. You know the difference between habitual and other types of residence? Are you following? You remember the concept of animus revitendi? That you can leave your home, but you leave some traces that you come back. Are you following? So residence is defined in not nationality, not citizenship. Where you reside is not your place where you were born. It can be some other place. Then it expands on what it means by writing. As I told you, writing would be very... So for the first time, this convention recognizes various forms of electronic communication. In international law, this is the way to go. Now, definition of mediation. We have a new definition of mediation. It defines it as a process, irrespective of the expression used or the basis upon which the process is carried out. So they don't go into the details of the procedures. And where parties attempt to reach an amicable settlement. Are you following? Amicable. Of their dispute with the assistance of a third person or persons. With the assistance. Called a mediator. Lacking the authority. This is very important. Lacking the authority to impose a solution upon the parties to the dispute. Are you following? So actually it takes care of all other definitions of mediation as we know it, and those are the elements which are available. So the convention deliberately avoid defining mediation prescriptively so as to allow for the wide range of differences in the understanding of the term among different jurisdictions, because there could be differences, but the basic principles are the same. Now, how mediations are conducted and what processes and modalities are permitted in mediation vary across jurisdictions, so you cannot put it in a convention. Now, the convention's broad definition resolves those differences by offering a definition that is simple and does not introduce any rigidity. So anything which resembles a mediation, so long as it is in writing, international, there is a third party who does not impose a decision, that could as well be within that range. It does not prescribe a specific technique of mediation. You as mediators, you'll be learning about a lot of techniques. That's not the business for the outcome, which will be a mediated settlement, however technique you use. Like, for example, evaluative, facilitative, transformative, and does not address whether or not caucus sessions can be used, and does not address whether or not the mediator can propose a solution. So caucusing, those techniques you've been learning here, are not part of the convention, but the final thing it should be a mediated settlement. Now, it addresses the obligation. General principle, Article 3, addresses the obligations of the parties to the convention. Now, this is where it becomes really tricky, because parties to an international convention are states, not the private businesses who are going to be covered by the convention. That's why I said we've taken mediation from the nation to the international. So now state obligations, so the states now, because they take care of all the businesses, they're supposed to have obligations under but the main players will be the private companies. Now, so it provides for affirmative enforcement of mediated settlement agreements. This is an obligation of a state. That is, private companies come to Bangladesh, they mediate. So when you go to Tanzania, the Tanzanian state, if it's a party to the convention, he has to enforce that. Otherwise, if you don't sign or ratify the convention, you will be safe. But actually, you are not that safe, because international business does not care whether you signed or ratified or not. Because when you go to borrow money, you are in trouble already. You fall under the XCD and in the New York, even if you didn't ratify. Now, the other one, the general principle, under the convention, the parties to the convention have the substantive obligation to enforce a settlement agreement. Of course, there are some exceptions, which you can put by way of reservation. Now, with this provision, the drafters deftly circumvented the fact that enforcement mechanisms for mediated settlement agreements vary across jurisdictions. But the problem is they wanted to achieve cross-border mediated settlement agreements. That is our biggest problem right now. Now, like the New York Convention, which leaves procedural issues to be governed by the law of the seat, that was my friend who was asking, the law of the seat, where you arbitrate and where you mediate, that's the law of the seat. This convention leaves those procedural issues to be governed by the state of enforcement. Now, where that mediated settlement is going to be enforced, that's where you use the rules of procedure of that country. Now, the second, the general principle also addressed the claim which a party considered to be an attempt to relitigate a dispute already resolved in mediation and provide for recognition of a mediated settlement agreement. That is where the word recognition is important. That we recognize that this matter has already been mediated. Why do you want to litigate it again? So it's kind of a res judicata. Because there are some parties who are clever, they jump forums. You know, I settle here, I'm not so happy, you have relitigated, you go somewhere to court to fight another case. So if someone brings the evidence that we set in a settlement mediation, you remember. You remember about the confidentiality thing? Now, when it comes to this, the confidentiality must come out. That is, actually, you went for a mediation. What are the terms you are not interested? We want to know only if you mediated and it succeeded or failed. By meeting all the conditions, a party seeking relief will be allowed to prove that the dispute had been settled. Are you following? So if you engage in a mediated settlement and someone wants to go to court on the same matter, you can go with that proof that we've already settled this matter. Of course, the next thing, that guy gets dismissed with the costs. Requirements for reliance on settlement agreements. Now, Article 4 addresses what a party seeking to rely on the settlement agreement must provide to satisfy the convention's requirement. You should note, given that mediation is in a cross-border dispute might well take place in a jurisdiction with no connection to the parties or to the dispute. Note this one. It's very important. Mediation can take place where in a jurisdiction with no connection to the parties or to the dispute. So Bangladesh could become an international center for mediation. Bring everybody to settle here. Then you tell them, take your mediated settlement and go enforce it wherever you want to. I follow. It brings money to the economy. That's what the Singapore is doing. That's what Mauritius is doing. Everybody is opening up international arbitration center. You think they want to see your disputes? They want to see your dollars. You know, most states do not know that you can make money out of people's misery. And one of which is to settle this. They say it is alternative dispute, it is costly effective, but you can argue later. Now, the issue whether or not confirmation in the state where the mediation took place should be required before enforcement could be sought elsewhere does not make any sense. You cannot make any sense by looking for confirmation. In any event, requiring such a confirmation would bring what the concept they call double executor. Now, double executor, which is a term also used in arbitration, it means that by requiring that the award become final and operative in the country where rendered before enforcement could be granted in other countries. We don't ask for that when it comes to mediated settlement. Now, the convention specifies what a party relying on a settlement agreement must supply to be competent authority of the party to the convention where relief is being sought. One of which is the requirements for reliance. In order to rely on the mediated settlement, you have to prove these things. One, a settlement agreement signed by the party. Signed. Now, signature also has its own definition. What does signature mean in the electronic world? Secondly, evidence that the settlement agreement resulted from mediation, which is logical. And I told you, in order for it to be mediation, it must fulfill the definition of what is a mediation. Now, which may be satisfied the mediator's signature on the agreement. You as mediators now, your signature becomes very important. Attestation by the mediator that the mediation was carried out is very important. And or an attestation by the administering institution. Like, for example, if the Bangladesh Mediation Center would be there and the institution which are administering, they can also attest that these parties actually came before this institution and settled. You remember the res judicata concept? You need it. Now, in order to allow for situations where none of these are available and to preserve the flexibility of the process, the convention permits evidence of the fact that the mediation took place by means of any other evidence acceptable to the competent authority. As students of evidence law, you know the meaning of this word. If you cannot prove by all those attestation and everything, bring any evidence which will convince the competent authority that actually mediation took place. Now, a signature or an attestation would be only to prove, this is the logic behind the signature, would only logic to prove the mediator's involvement in the process and is not to be construed as an endorsement of the settlement agreement. It's not an endorsement, nor as an indication that the mediator was a party to the agreement. So it is for other purposes, because that is your own. And the logic is very simple, because the mediator is not a party to the, is only assisting you, right? So it is your own mediation settlement. For that, signature is only to prove that you appeared before the mediator, and actually you settled. Now, whether an unassisted negotiation, which leads to a settlement agreement, should also be covered by the convention, it was also an issue. So they finally decided that the convention should be limited only to mediated settlements. Final. You must decide on the subject of the matter. The other requirements of reliance, the convention expands on how the requirement that a settlement agreement shall be signed by the parties or where applicable, the mediator is met in relation to electronic communication. Because in contemporary times, we use electronic signature and the digital signature. Do you know the difference between digital and electronic? Digital means you cannot see it. That's the meaning of digital. This is encrypted. It's very difficult to make it. Electronic signature is very simple. You just go to a program and you sign and that's it. Most people do that. But digital is a little bit complicated. Now, grounds for refusing to grant a relief. You can actually actually go to a competent authority to contest the relief. Article 5 encompasses both the right of a party to seek enforcement as well as to invoke a settlement agreement. Now, and both of these reliefs may be refused by the competent authority. Competent authority here is a broad term which includes any type of court by the name you call it in that country. You know, in most countries, they limit the court which can handle this kind of disputes. Could be the High Court. Now, and both these reliefs may be refused by the competent authority if the objecting party furnishes the requisite proof with respect to any of the grounds provided under Article 5. And I try to summarize the grounds. And actually, it takes care of the two principal grounds specified in the New York Convention. I told you they also uplifted some of the provisions from the New York. So when you read the Singapore Convention, sometimes you may slip over, think that I'm studying the New York Conventions. You have to be very careful. Look for the word mediated, not the arbitration. And you know you are in Singapore, not in New York. Now, if you want to oppose the mediated settlement, you have to prove one or any of these provisions. One, there are substantive grounds for objecting. This includes incapacity of a party to the settlement agreement. And you know incapacity is a legal term, right? For example, if you enter into a mediated settlement with a child of 5 years, you are in trouble. Because that child suffers from legal incapacity, or a lunatic, or person of unsound mind. Those are the legal issues, you know. And then settlement agreements is null and void, inoperative, or incapable of being performed under the law to which the parties have subjected it. Now we are having a concept like the New York Convention. You can subject the settlement to a certain law. So under that law, if it is incapable of being enforced, that's a ground for refusing. Another one is the grounds relating to the terms of the settlement agreement. You remember my friend here was talking about you drafting the settlement agreement. Now in mediation also we'll be drafting a settlement agreement. The settlement agreement is not binding or is not final according to its terms. So you have to be very careful in how you draft that settlement agreement. Now grounds relating to the mediator's conduct and the process I told you now has been brought on board. A serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach the party would not have entered into the settlement agreement. My friend Mendelin was talking about ethics. This is where the ethical conduct, professional misconduct of a mediator comes in. If you misconducted yourself, it could be a ground, corruption, you know, all those kind of things. Sua motu or sua ponte, grounds in which are invocable by the competent authority of the party. The competent party, like many high courts, they have that inherent power. They can act on their own without even being moved if they smell rat. Now, failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality to independence. Remember the ethics there? It can be a ground now for objecting to the enforcement of the agreement mediated settlement. So ethics for a mediator is very crucial. We have not yet had a decision by any court which will tell us that mediators' conduct is almost the same standard as arbitrators. But I think soon it will be coming into force. For arbitrators, it's now settled, the same standard as judges. And I'll give you a citation of that case which I mentioned. There are two cases which I say, I always used to tell my students that you don't have to read every case under the sun. You are not an angel. You only read one case which will cover about 100 principles. Are you following? Are you using that trick? Otherwise, you will fail your exams. So the settlement agreement has been subsequently modified, or obligations in the settlement have been performed or are not clear or incomprehensible. As I told you, you can actually go to court and say, we have already settled this matter. Why is this guy coming up with this other agreement? Now, granting relief would be contrary to the terms of the settlement agreement. So even the relief must be mentioned. What kind of relief? Granting relief would be contrary to public policy. You remember about public policy? And they say, like the English judge who said, public policy is an unruled horse. It can lead you anywhere. Nobody has been able to define what is public policy. Actually, some places they can say that if you do things which the president of the country thinks that this is contrary to Bangladesh morals, it can be public policy. And then the subject matter of the dispute is not capable of settlement by mediators under the law of the party. Are you following? So you have to be very clear. It's only matters which are mentioned are capable of being settled. Like family settlement and international mediation is not possible. We cannot settle international family disputes. Now, parallel applications. Now, the Article 6 grants that discretion to adjourn the decision so that you can take advantage of other tribunals. Yeah? If you say, I think we can go to other tribunals, they allow it. Now, also, the provision also apply when the agreement, enforcement of a settlement agreement is sought and when a settlement agreement is invoked as a defense. This is a big distinction. You can invoke that provision if you want to enforce the mediated settlement. Or you can invoke it, as I told you, as a way of showing that we have already mediated this matter. So you are invoking settlement agreement as a defense. You are not relying on it as a cause of action. Now, the law, the treaty also preserves a party's right to avail itself of a settlement agreement pursuant to other laws or treaties. You know, you are allowed to do that, to which the contracting state is a party. Now, there are the convention also allow for reservations. You know, in international law, if you assign and you ratify, you want to be bound, but you can say these certain provisions are not binding on you. Now, you can, Article 8 addresses those two issues, whether the convention should apply to governments or governmental entities. You know, our governments in the third world, they are very smart. When a matter is in their favor, they go for it. When it is not in their favor, they say we have immunity. And then you go to court to argue.
Sovereign immunity.
Yeah, sovereign immunity, yeah. So whether the party should be required to opt in for the convention to apply. Now, the convention provides state parties with the option to make the following reservation. There are only two reservations. One, states and other public entities. This reservation permits a party to the convention to provide that the convention will not apply to settlement agreements to which it or any governmental agency or any person acting on behalf of a government agency is a party. So as a lawyer, you can advise your client, if you enter into business with this government entity, now this is what might happen in case of a dispute. So they will prefer to go to their national courts, not to take them to international mediation.
So this is, Iran has opted this reservation.
Yeah, Iran is the one who used this option. When they were signing, they were very clear. You can actually put reservation when you are signing or ratifying. In international law, a treaty, when it is concluded, parties who are present can sign, but signature does not mean a lot. You are actually now required to ratify. And in common law countries, after you ratify, you take the convention to parliament so that it can be domesticated into national law, either as a schedule or with certain provisions. Now, the opt-in reservation. This reservation permits a party to the convention to provide that the convention will only be applicable if the parties opt in and have affirmatively agreed to the application of the convention. No other reservations are permitted under the convention. It is the same as the New York Convention, only two reservations. Because if you allow too many reservations, the convention will not make any sense because the parties can opt out in every provision, so they will not have any convention. Now, effect of settlement on settlement of agreements, it is specified that the convention and any reservation or withdrawal apply to settlement agreements included after the date to which the convention, reservation, or withdrawal enter into force. Now, depository, of course, you deposit with the UN General Secretary General of the UN. This is what I told you now. Mediation is being given that international kind of appearance, and you know the accession, what it means, negotiated and signed, and when you accede, because you can accede to a convention after it had come into force, you can become a member. So it has the same effect as a ratification. So I'll show you the states which have signed the convention. Do you see Bangladesh there? It's not there. Tanzania is not there. We have not signed. We are still thinking. We are seriously thinking. And you are holding meetings to think. Finally, we may end up saying we have stopped the thinking. So we are not signing. I'll tell you a story. Tanzania signed the New York Convention in 1964 and ratified it in 1965. To date, they have not made any law to implement it. Are you following? 65 years, we are still thinking. Medellin has been making a lot of noise here. Nobody is listening.
Some more food for thought.
When I was in court, I always have a problem. Our arbitration law is the same as the Bangladesh arbitration law of 1940. Because what the British did, they thought, oh, the colonies are the same. They look like Bengali, Tanzanians, but they think the same. So give them the same law. And we have trouble today. For them, they have changed the law. We are still struggling. So the big guys, they are there. China signed. South, the US, of all the countries, of course, they are very slow in signing agreement. You know why? Because in the United States, when you ratify, now because this is the first step, when the US ratifies a treaty, if it's a self-executing treaty, it becomes law automatically. You don't go to Congress. So they are very careful when they are. But then for the rest of us, we go there, it's a ceremony. We ratify and then we forget. Now, and that's not a very good thing. I'm not saying this because I'm retired. Even when I was on the bench, I used to tell the government the same story. Because that is the way to make the law change. This is not a public policy issue. It's not, no, it's not a national security issue. Now, participation by regional economic integration organizations are also allowed under Article 14. You know, the ASEAN, they are allowed to join, and regional economic integration, they are allowed to do that. Non-unified legal systems, the Article 13 permits states to the convention to declare that the convention would extend to all its territorial limits or only to one or more of them. You know, Europeans are still having some interest in Netherlands to the Antilles, you know, I follow. So whenever they ratify a convention, they also extend to their new colonies. And that is the provision which is allowed under the computer has stopped moving.
No, you have to close that dialogue.
Ah, okay, sorry. It is low on the battery. Okay, let me finish. Now, entry into force, this is a convention. It says it will enter into force 6 months after the date of deposit of the third instrument of ratification, acceptance, approval, and accession. To date, no state has entered any ratification, so we are still waiting. Only 3 states are required, which is a very low threshold. Are you for it? So, are you for it? 46 states, on the date it was adopted, they signed very fast. To date, they are still thinking. That was in August 2019. I think we can give them a leeway that the state takes about 1 year to think. So maybe we hope by next year we shall see. Now Article 15 allows for amendment and adoption of the amendment. And actually you can also, states are allowed to denounce. They say, we don't want to be bound, we made a mistake. So, but they can do that by notification in writing. Now, in conclusion, I am saying you can argue with me, disagree or agree. This is my own opinion. There is some light at the end of the tunnel. You know the tunnel? Enforcement of international mediated settlement. We previously did not have even a convention.